Good morning to one and all. I'm Rama Punangi, a research assistant in GW Law Program. Today, I have the pleasure of introducing Lisa Thiele. Lisa Thiele is Vice President of Legal and Commission Affairs and the Senior General Counsel at the Canadian Nuclear Safety Commission. Lisa has extensive experience and expertise in nuclear regulatory law, both the national and international levels. She represents Canada as a member of Nuclear Energy Agency's Nuclear Law Committee and chairs its working party on the legal aspects of nuclear safety. She has been a faculty on International Atomic Energy's Nuclear Law Institute and a regular lecturer at Nuclear Energy's International School of Nuclear Law, which I have the pleasure to attend. Today, Lisa is going to be talking about regulating uranium production, environmental stewardship, Indigenous Consultation, transparency in Canada. The floor is yours.
Thank you, Rama. Sound is good?
Yeah.
Yes, okay. So good morning, everyone. I'm very pleased to be joining you from Ottawa, Canada this morning to be speaking, as Rama said, to you about how the Canadian Nuclear Safety Commission regulates the front end of the nuclear fuel cycle, which is to say uranium production. So in my short time, I'm going to first take a little glance back at past practices, because that provides good context for our focus on how we regulate today. And certainly in Canada, we regulate uranium production with the regulatory focus on safety, environmental stewardship, and transparent, inclusive processes. Then at the end, before concluding, I'll say a few remarks about some international soft law instruments which are not about domestic regulating by the Canadian regulator in Canada, but certainly important context for the extractive sector, which is very multinational in nature. So without further ado, past mining practices. I think we know that legacy sites are everywhere, and they're characterized by old mining practices, Cold War secrecy, not a life management approach, and that is what we sort of, the legacy of which we suffer today. New sites, of course, are reflective of internationalized standards, prevention and mitigation of risks to health, to the natural environment. It's a highly regulated industry now. I have a case site there for a company that actually did uranium mining operations in the 50s and 60s, and today is now, according to this decision, and if anyone wants to get a copy of it, I'm happy to email a copy of it to them. Rio Algam, because it still exists today, it will be liable in perpetuity for the management of tailings for some of these past practices. So that's sort of the legacy that we deal with. This is not just in Canada, it's everywhere, all over the world. And I think a couple of things to note. Firstly, remediation of former sites can actually be more challenging than doing it right the first time. And that's to be kept in mind, because these are challenging remediation progresses. And also, new mine acceptance can often be judged by how people think old sites have been treated. These photos are of a modern mine decommissioning project in the Athabasca Basin, which is in northern Saskatchewan, Canada. Okay, enough about the past, but that's the context. Regulating uranium production today, protection of workers, protection of the public in terms of dose, and protecting the natural environment, including site decommissioning, planned remediation, and return to nature. The regulatory process starts with environmental impact assessment, which predicts the effects of a proposal, mine production proposal. And it also has a lot of process elements, ensuring public discourse with respect to a project. Canada's Impact Assessment Act considers many potential impacts: environmental, economic, social, health, gender, impacts on Indigenous rights, and impacts that are both positive and both negative in terms of their potential. I'm not going to speak in any detail about our Impact Assessment Act. There are some details there. What I will say is that there has not yet been a Canadian operating mine that has gone through this particular statutory process. The existing mines went through former environmental assessment legislation. But the Impact Assessment Act, if you look at the key participants in this system, you will see that there are a whole lot of participants, and it is meant to be a very participatory process. Specifically with respect to environmental impact assessment of uranium production, this process links the political to the scientific. It's about social impacts as well as impacts on the natural environment. And when you're talking about a uranium mine proposal, social acceptability is one of the impacts to be considered. I have a case cite there from a 2017 decision where, despite the fact that the governing statute on environmental assessment did not include the term social acceptance at all, the court was very satisfied that both that the idea that fit within the statutory principles and that the environment had to include the social environment. And so that's pretty important context. Okay, that's the environmental impact assessment process. And then once that's concluded, the Canadian Nuclear Regulator, the Canadian Nuclear Safety Commission, undertakes its licensing process. This is a life cycle approach. It is a cradle to grave approach. Each stage, site prep, construction, operation, decommissioning, and eventual release from licensing to institutional control, each of those steps has to be authorized by license. It's not 5 different licenses necessarily, but licensing can't do it without a license. The licensing process itself is a transparent process. It involves public involvement, public participation, and participation by Indigenous groups. Easy to say, how do we do it? The Nuclear Safety and Control Act is our governing legislation. It allows the Commission to put in place a participant funding program, which is a very important part of how we make sure that our licensing processes are open and inclusive. So there is an external funding recommending body. Potential interveners in the process apply for funding. This is capacity building. It's great capacity building for Indigenous groups who perhaps want to do Indigenous knowledge studies for a region that is at issue with respect to a proposal. It actually funds transportation to a hearing in order to facilitate active participation. And so that is one important way that we make sure our processes are open and inclusive and participatory. The statute requires a public hearing for any licensing that the Commission does. Financial guarantees are another important aspect of the life cycle management of mine regulation. Now, Canada has, our federal provincial relationships in the way that the US has federal state relationships. In Canada, the mineral rights belong to provinces. So front end, very front end, it's provincially owned. When a proponent wishes to construct a uranium mine, that becomes nuclear fuel cycle, and it's the federal nuclear regulator that regulates. So financial guarantees are put in place and are required by license throughout the life of a project. And this is how we make sure that there is a closure plan, there is a remediation plan, there is a decommissioning plan, and it is costed and going to be paid for. Okay, so that's big picture of the licensing process in a quick nutshell. I'd like to speak a bit about Indigenous rights and uranium mining. Certainly in Canada, as elsewhere, Indigenous peoples live in places with valuable uranium ores. The UN Declaration on the Rights of Indigenous Peoples, getting strange messages, was adopted in 2007 by the UN General Assembly. I note that of the 4 UN member states who voted against it, Canada and the US were both in that category at the time. It altered the political and legal landscape from rights to claims in terms of Indigenous rights. It recognizes land rights, self-determination, autonomy as collective rights of Indigenous groups. Seem to advance my slide. Rama, do you think you could advance my slide for me?
I don't think I can do it from here.
Not sure why I can't advance it anymore. Oh, there we go.
Oh,
sorry, I've fixed it. My apologies.
no problem.
There are a couple of provisions of the UN Declaration that are important to uranium mining. Certainly free, prior, and informed consent for the approval of anything affecting lands, territories, and resources, particularly in connection with mineral, water, or other resources. So you can see the importance of the UN Declaration. Notwithstanding the Declaration, Canadian constitutional law imposes on the Crown, the state, which is the Crown in Canada, the duty to consult and potentially accommodate Indigenous groups whose rights may be affected by a decision by the Crown, for example, the licensing of a uranium mine. The Crown, which is the CNSC in this instance, and that's established by the decision that's cited there. The Crown relies on project proponents to engage with Indigenous groups, to address their concerns, to learn about their interests, to learn about what's at stake, and to bring all of that to the licensing process. UN Declaration was signed by Canada in 2010, adopting it as an aspirational standard of achievement to be pursued kind of soft law instrument. And then very recently in 2021, the Canadian Parliament enacted the UN Declaration on the Rights of Indigenous Peoples Act, which is to ensure that the laws of Canada are consistent with the declaration. So that puts into Canadian domestic law the UN Declaration, and there's an action plan underway in order to effect that. And that action plan is meant to achieve the objectives of the declaration within a 2-year period. So that will inform certainly how we operate domestically. So I'm going to say just a few words about some of the context of international soft law instruments. Of course, they're not legally binding, but they can contextualize existing law. They can lead to the development of customary international law, and the extractive sector is certainly a sector that is characterized by multinational enterprises. We have OECD due diligence guidance for meaningful stakeholder engagement in the extractive sector that come from the OECD guidelines for multinational enterprises. And they have very specific recommendations with respect to stakeholder engagement, how you do so, how you integrate stakeholder views, local views, on the ground personnel, identifying the stakeholders, how you ensure follow-up with respect to the issues that matter to them, paying particular attention to Indigenous rights, to the rights of women, to the rights of workers. So that's important context. Coming back a bit to Canada, Canada, of course, has our OECD national contact points, and that role comes from those guidelines, and that's a mediation facilitation role. We now have a Canadian ombudsperson for responsible enterprise, a fairly recent thing, which provides a voluntary dispute resolution mechanism that is complementary to the national contact points. So it's in Canada, dealing with multinationals operating elsewhere. Extractive Sector Transparency Measures Act and such also contribute to the structure, of which it is important to be mindful. Don't have much time left. Just it's worth noting that some of how we contextualize existing laws can certainly, the principles can definitely impact how courts decide cases. Couple case citations there, and I won't talk about them for very long. But for example, does a Canadian, not uranium, nickel mining company owe a duty of care to protect Indigenous peoples from human rights abuses in Guatemala by the company's subsidiaries? There is no definitive answer to that question in Canada yet, but so far it's a maybe. The case is ongoing, and so it's important to be mindful for corporate liability and corporate responsibility in terms of all of this governance. Okay, I think we should have a little bit of time for discussion. So I'll just say, by way of summation, distinguishing current mining practices from legacy practices, environmental impact is key. Impact assessment brings together process and substance. There are participatory rights. It has to be a participatory process. Lifecycle management is primordial to the scheme. What makes a project acceptable includes all of these things that are listed there. And from a regulatory perspective, the regulatory perspective has to be seen to be transparent, to be listening, to be participatory in order to earn the trust of the population, that social acceptability isn't governed by the regulator, but the regulatory process has to be transparent in order to be trustworthy. And finally, global initiatives with respect to governance and human rights, maybe they don't themselves create hard law, but states can make them hard law, and they may generate legal requirements for industry on their own. So on that, I will end and hopefully have a bit of time for a bit of discussion.
Thank you, Lisa. This is Donna Atanasio. We do have at least one question. Let me just take a moment to remind the audience that please type your questions into the Q&A queue, and we will get all of them answered to the extent we can. Our first one actually is coming from one of our students, and he asks, what does accommodation for nearby residents in Indigenous groups and nations often look like in the context of often rigid by necessity plans?
Okay, so maybe I can give you a real life example. Some of these mine sites are in remote areas. And so the mine proponent, as part of the project description, will speak about the roads they're going to construct to get to the future mine site. And so it is through a consultative process with a local Indigenous group who might, for example, have mining rights, trapping rights, fishing rights. If the roadway is actually going to mess up trap lines, an accommodation measure might be reroute your road. Make sure that it isn't messing with trap lines or even routes of important wildlife that are hunted. And so the accommodation can be as simple as not interrupting existing and well-established ways that Indigenous groups exercise their treaty rights. Does that answer the question?
Well, it's certainly a nice segue into the next question, which is asking for suggestions on how project sponsors and participants can effectively engage Indigenous groups. I mean, I think you've given an example of when you've gotten the feedback, but I know that even when we try to engage community groups, knowing who to reach out to, what that process should look like, how do you include the Indigenous population in the decision-making process, as well as assuring they have a just outcome. Can you talk a little bit about how you've approached that part of the process?
So I think there are two parts to that, because I think there is a piece for the regulator and for the regulator to be out there. But I think even before that, project proponents who've been involved in exploration in the communities need to be actually on the ground and actually sussing out the communities. The CNSC has a regulatory document on engagement, and it sort of sets out what is expected of project proponents in the lead up to having an application for a license. And that includes properly identifying and communicating with and reaching out to groups who may have interests, whose rights, either asserted or established, may be affected, or who may simply be interested in what's this project that you're thinking about that might be near to me, might not be near to me. And I think that certainly in Canada, there are federal government resources and provincial government resources to identify treaties, areas, land claims, all of that. But I think you can't really substitute someone actually being in local communities. And so that's sort of the expectation that is on proponents, that is a part of the evaluation process. From the regulator's perspective, the regulator too, as the Crown, Canadian constitutional law requires the Crown to act honorably vis-a-vis Indigenous groups and vis-a-vis the protection of their rights. And so the Crown too, independently of proponents, should be in communities. The CNSC has a team of our Indigenous relations group, and they actually work on relationship building with Indigenous communities across the country. And that's where there may be nuclear facilities nearby, there may not. There may be future nuclear facilities nearby, there may not be. It is an outreach that is done, some targeted, yes, where there are potential projects, but also in a general honor of the Crown kind of way.
That's really helpful. And this all relates so very well to the earlier comments we had and Fiona Riley's talk about diversity. And as you're speaking, it occurs to me how much better the process goes if rather than going to the community and saying, here's where we want to route the road. This is our plan. What's wrong with it? If instead the question is, we would like to be able to route a road through here. Can we all talk about what the best route would be? If you start at the beginning point and bring those voices in earlier, often the result, it goes a lot smoother.
And that's the thinking. And we're always learning, right?
Yes.
It's not like we have had all the answers or do have all the answers. But the good faith efforts continue, and we're always learning, and we're always looking to build and flourish those relationships.
We have another question which says, which sources of energy requires the most amount of mining? It's a very specific question. I don't know if that's part of your scope of your responsibilities, but
no earthly idea. Sorry. I'm a lawyer.
It's an interesting question, though, and I think it does go very much to the problems that we were discussing earlier about life cycle and all the different technologies that all have their own demands. So interesting. If you don't mind, can we take a couple more questions? We have a little bit of, I know we've got to get you out of here so you can get your plane, but we have another one here that says, how much interaction or coordination is there between the CNSC and the U.S. Nuclear Regulatory Commission?
Oh, that's a great question. And quite a bit, I will say. I know your conference opened with my friend Steve Burns. I've known Steve Burns since he was the Deputy General Counsel at the US NRC, and I was the Deputy General Counsel at the CNSC. And so our regulatory cooperation is an important part of global nuclear regulating anyway. And I will say with the Canada-US relationship, it is that much richer. I think you probably will be talking about advanced technologies at some point this week.
We will.
And in that context, I will say that our standard regulatory cooperation and information sharing relationship with the US NRC that we have with most other regulators as well, to be quite nuclear regulators, is enhanced. A couple of years ago, the president of the commission signed alongside the chairman of the NRC a memorandum of cooperation specifically to deal with how the two regulators could work together on advanced technologies, work toward harmonization, work toward joint reviews. How could we compare notes? And that work it's hard work. One of the first reports that was done under that memorandum of cooperation was a comparison between the general regulatory approach of the US NRC as compared to the general regulatory approach to reactor technology of the CNSC, and were they compatible? And could we actually do work jointly? And could we actually avoid some duplication? And that hard work actually does lay the groundwork for that joint work. So yes, long-winded answer. We do cooperate in regulating fairly closely, which is great.
I think that takes us to the end of the questions and about the end of our time. So this worked out quite perfectly. Lisa, I can't thank you enough. This has really been wonderful. I think you've set us off on a good path to now move on this afternoon to talk about the US system. And we hopefully will get some input from around the world on other thoughts as well. But again, thank you so much. I want to remind the audience that we have a short break right now, and we'll be starting again at 11:45, and that will take us into a discussion about the U.S. system, followed by a panel discussion. Thank you so much.
My pleasure, and enjoy the rest of your conference.
Thank you.